The EB3 visa, a subcategory of the employment immigration visa, is a powerful option for professionals, skilled workers, and unskilled workers hoping to get permanent residency in the United States. Through the EB3 visa, a U.S. company can sponsor a foreign worker for a green card through a full-time job offer. Raju Law, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.
Hello everyone, welcome back to our weekly live session with Attorney Raju Mahajan and Associates. For today's show, I'm your host, 𝗦𝘂𝘃𝗍𝗆, and with that, let's welcome our principal guest, none other than the founder and the principal attorney, Mr. Raju Mahajan. Mr. Mahajan, how are you today?
I'm good. Thank you very much, 𝗏𝘂𝘃𝗍, and I welcome everyone in our show today. Those who are watching right now and will watch in future, like a YouTube, Facebook, LinkedIn, and other social media.
Thank you, Mr. Mahajan. Today's topic is on a very important matter that involves change of status from B1, B2 to F1 category. Mr. Mahajan, please share your thoughts on this topic.
Thank you. Can I see the PowerPoint? Yes, thank you very much. Today we are going to talk about change of status. Recently, this is a very hot topic. A lot of people, they come to America with a B1 or B2 visa, and then they want to change their status from that non-immigrant category to other non-immigrant category like F1. So that's a very common issue right now, but I'm not just going to talk about B1, B2 to F1. This is a very generic discussion about change of status, meaning change of your status from any non-immigrant visa to kind of other non-immigrant visa. So definitely it will cover B1, B2 to F1, but also it will cover other topics. Next slide, please. So here, before going to talk about change of status, I just want to tell that there's two terms, and many people, they're confused about these two terms. One is change of status, and another one is adjustment of status. So change of status is when you apply for change of your status from one non-immigrant status to another non-immigrant status. That is called change of status. And usually it is in between F, B, O, L, H, Q. There are many other non-immigrant categories. So when you change your status from one non-immigrant to another non-immigrant, then it is called change of status. And the form you need to fill up and submit to USCIS to do this is called Form I-539. However, there's another term called adjustment of status, meaning you are adjusting your status from a non-immigrant status to an immigrant visa. So when you're going to apply for a green card from a non-immigrant visa category, it is called adjustment of status. And the form for that is called I-485. This is a totally different thing, but a lot of people, when they reach out to us and they ask questions, they are kind of like confused about these two terms. So I just want to make sure that you are not confused about it. And today we are going to talk about change of status, not adjustment of status. We may talk about adjustment of status on another day. Next slide, please. So there are some important information about change of status. At first, I'm going to talk about that, and then we'll go to detail about required document list, attorney fee, USCIS fee, and other things. The first one is, if you want to change the purpose of your visit while in the United States, you, or in some cases your employer, must file a request with USCIS on the appropriate form before your authorized stay expires. So these last few words are very important. You must submit your change of status before your authorized stay expires. A lot of people, they come to us and they say, hey, I came to America with a B1, B2 visa. My 6 months stay has been expired. Now I want to change my status to F1. You cannot do that. Once your authorized stay expires, you are unauthorized at this moment. If you go to an unauthorized status, that is really, really bad for your immigration future. So please do not try to change of your status after your authorized stay is expired. You must do it before your authorized status is expired. The next one is, until you receive approval from USCIS, do not assume the status has been approved and do not change your activity in the United States. A lot of time, for pretty much all kind of immigration things, once we submit the application to USCIS, we receive a receipt notice. The purpose of receipt notice is just to notify that USCIS has received your application. They did not approve it, they did not deny it, they did not take any action on that. They just received it. As soon as you receive the receipt notice, a lot of people, they assume that, oh, my application has been approved because they received it. Now I'm going to my other activity. A lot of time, especially some universities, some DSOs, they don't know. So what they do, let's say you come to America with a B1, B2 visa, you got admission to a university, let's say it's called ABC University. You applied for change of status, you got the receipt notice, and university will tell you, hey, you have the receipt notice. Now you can start, enrolling for programs, you can pay your tuition fee and start going to school. You cannot do that. You cannot do that just because your school officials said that. Most of the DSOs, they are not attorney, they have no legal knowledge, they have some training about USCIS forms and other thing, and a lot of time, they just want to make money. Universities want to make money. That's why they will say, well, since you have a receipt notice, you can enroll, you can pay your tuition. The answer is you cannot until your change of status application has been approved. Just because you received the receipt notice, it doesn't mean that your application has been approved. A lot of time people ask me this question. That's why I'm going a little detailed to explain the situation. Just because your school officials said that it's not legal, you have to follow. For any information, you must talk to an attorney, or at least go to a USCIS website and double check with any information from there. Next slide, please. Also, you do not need to apply to change your status from B1 to B2. This is kind of very confusing thing, even from USCIS. USCIS should make it a two different category, but they call it B1, B2. So let's say you came to America for a business purpose with a B1 visa, and your business work is done. You're free now. You want to visit some, friends or family, and you want to go some beautiful places like Niagara Falls or Grand Canyon. So the activity you do in America under B1 is business related. However, once your business activity is over, if you want to do some vacation kind of time, you do not need to change your status from B1 to B2. B1, B2 is kind of like the same thing. It's just a different purpose. So you do not need to change your status from B1 to B2. A lot of people ask me this question too. Next one, J2 visa holders do not need to change to F1. In America, a lot of people, they are in J1 visa. So once someone is in J1 visa, their dependents, their spouse, their children, they get J2 visa. And once someone is in J2 visa, they decide like, hey, I want to go to school, I want to study other things. So if you are in valid J2 visa, you do not need to go to F1 visa. However, there are some benefits that is associated with F1 visa. If you are not in F1 visa, you will not get those benefits like, CPT, OPT, pre-completion OPT, post-completion OPT kind of things. You will not get those things if you are studying under J2 visa. However, if you say that, hey, I don't need those things, I just need to go to school, I just need a degree, in that scenario, you do not need to change your status from J2 to F1. But if you want to do that, you can do it. Another thing is J1 must receive waiver before change to F1. A lot of people, when they come to America under J1 visa, it comes with a home residency requirement, meaning it says that once your course of activity is over, you must go back to your home country, work in this field for at least 2 years, then you can come back to America. Not all J1 visa has this requirement. Some J1 has this requirement, some don't. If you do not have any requirement under your J1 status, then it is kind of like very similar to F1. You can do many things. However, if your J1 has this kind of home residency requirement, you must receive waiver before you change up your status from J1 to F1. A lot of people, they don't know this, so I should make it clear. Next slide, please. All right, now the question is, once you apply for change of status from any non-immigrant to another non-immigrant status, what are the forms that you need to fill up? Number one, the form is I-539. Also, if you have an attorney, the attorney will fill up G28. There's another form called G1145. So the purpose of G1145 is just to receive cell phone notification or email notification from USCIS. This is a simple one-page form. I really recommend all of you to submit this form because this is really helpful. Next form is I-907 if premium processing is needed. So a lot of time, this is a very new development. USCIS recently introduced premium processing in change of status application, and this is really, really beneficial for those who are changing their status, because before premium processing, a lot of time, it took a long time to change your status, especially from B2 to F1. It took a long time. Sometimes it took a year just to change your status. But recently, USCIS introduced premium processing, and it's really, really helpful. However, it's a little expensive. You have to pay additional $1,750. I understand it's a lot of money, but at the same time, it's really beneficial. So if you apply under premium processing, you have to submit the form I-907. Next slide, please. All right, timeline. Typically 2 to 6 months, but we have cases that have been approved within a month or so. So even before premium processing, sometimes we got it very fast within 1 or 2 months, but typically it's 2 to 6 months. Sometimes it goes beyond 1 year. But recently there's a premium processing. So with premium processing time is only 15 days. That is a really good news for those who are trying to change your status. Next slide, please. All right, fees. I-539 filing fee is $370. Biometric fee, if needed, is $85. I-907, which is premium processing fee, is $1,750. Again, a lot of time USCIS changes their fees very frequently. So anytime you apply for any application, please double check the latest fee, USCIS fee, and you must pay the appropriate fee, the exact fee. Even if you pay more, they will return your application back to you. So you have to pay the exact fee. And also attorney fee for regular processing, we charge $1,050. And for premium processing, we charge $1,450. That is our fee. Next slide, please. Required documents. So when you submit your application, there's a lot of documents you need to submit. The first one is identification documents. Number one, you have to have a passport, valid visa stamp, I-94, I-20. I-20 is very important. A lot of people, they don't know. Like when you change your status from B2 to F1, I-20 is a mandatory. You must submit your latest I-20. Otherwise, your application, they will not even receive your application. Admission offer letter, service fee payment document. Next slide, please. So also you have to prove your financial report. You have to submit your financial report. You have to establish that the time you are staying in America with a new status, like meaning probably F1 status, you are eligible, you are able to pay yourself. So the typical question is how much you have to show as a financial support. Usually you have to show 1 year's tuition and 1 year's living expense in that area, in either in your bank account or your first blood, meaning your immediate family member, father, mother, brother, and sister's bank account, or any American citizen who live in America can sponsor you. This is a very interesting information. A lot of people, they don't know it. So let's say you are in America with a B2 visa, you're changing your status from B2 to F1, and you do not have that much money in your bank account. Your parents living in a foreign country, they don't have enough money. However, there is an American citizen who is your just friend. You just met him or her a few days ago. He or she has enough money, so he or she can fill up a form called I-134, and that person can sponsor you. That person needs to show that he or she has your equivalent to your 1 year tuition and 1 year living expense equivalent money in his or her bank account. And they must also submit 3 months bank statement with your application. Next slide, please. Also, you have to submit a personal statement explaining your situation. In the personal statement, you must mention which visa category you originally came to America under. For example, you came with a B2 visa. You must say why you came to America with a B2 visa. Let's say you came to America to visit, your friends and family, beautiful places. You must say that. And remember, when you write this personal statement, you must say the same thing that you said to embassy in your visa interview. Before visa interview, when you submitted your form DS-160, these two information must match with each other. A lot of people, what they said in their DS-160 form and what they say in this I-539 form do not match. If it doesn't match, then it may create some problem. So in your personal statement, you must mention your original visa category, the purpose of your visit, and you must also mention your intended visa category and the purpose of the category. For example, if you want to go to F1 status, you must say that I'm going to enroll to this XYZ university for masters in media studies or masters in computer science. I want to study 2 years. So try your best to give as information as possible, as much. At the same time, all the information must match with each other, and try to be as precise as possible. At the same time, you must mention your non-immigrant intent, meaning after this course of study or after this activity, you are going back to your home country like your previous intent. You cannot say that after this course of study, I'm going to apply for green card. That will violate the requirements for non-immigrant status. So in the personal statement, I wrote a lot of things here. Those who are watching this video now or in the YouTube, you can read it. I'm not going to read everything. Bottom line, in your personal statement, you must clearly mention your non-immigrant status, your future plan, what you're going to do, where you're going to live, and how long you want to plan, and what is the exact date of your start of your new status. Next slide, please. All right, required documents for dependents. A lot of time, when people come to B2 visa, they have dependents. And when you apply for change of status, you must also change of status for your dependents. Just because your status is going to change from B2 to F1 doesn't mean your dependents visa is automatically going to change. You have to submit application. You have to submit application to change from B2 to F1, and your dependents will submit application to change status from B2 to F2. Dependency status is F2, or like other kind of category. So they also need to submit their passport, valid visa stamp, I-94, I-20 for F2, your family photograph, your marriage certificate, birth certificate of your children. So there's like a lot of information just to prove that you're a family member. You're not just a random person. Next slide, please. Okay, that was our presentation for change of status from one non-immigrant status to another non-immigrant status. If you have any question about this, I'm happy to answer. If you have other question about other topic, I'm happy to answer too.
Thank you so much, Mr. Mahajan, for this informative discussion. I'm sure all of us are now more knowledgeable on this issue than we were before it. We have received some questions. The first one is from Mr. Mahadin Mahabub Khan. Hi, I am currently on F1 visa, finished my master's recently, and currently I am on OPT work authorization. On a separate application through my mother, principal applicant, I have an immigrant visa application going on. As a dependent, I am on F43. That one is documentary complete since March 2022. And my parents and me, are being asked to wait for an interview in Dhaka. Since then, my question is, can I do adjustment of status from here in the US without waiting for visa interview?
I am assuming you want to adjust your status with your family-based application under your mother's application. It depends. It depends on the visa bulletin. If your application, if your priority date is current in both the boxes in visa bulletin, there's two boxes. One is final action date. Another one is date for application. If your priority date is current in both of the boxes, then yes, you can adjust of your status from within America. However, if it is not current in one of those boxes, then you cannot adjust here. You have to wait until your priority date is present in both of the boxes of visa bulletin.
Hope that answers your questions, Mr. Khan. Our next question is from Ms. Fatima Tasmia. If a F2 visa holder changes status to F1 within USA, does he or she still need to face an interview in the home country? If yes, then is there any chance to get rejection from this embassy of home country during stamping of the F1 visa? And will also he or she be able to avail the opportunity of Dropbox for stamping?
The first question is yes. Once you change of your status from F2 to F1 from within America, as long as you're not going outside of America, you're good. You do not need a visa stamp. However, if you leave America to any country, including Canada, Mexico, or to Bangladesh, or any country, once you try to come back to America, you must have a valid visa stamp in your new status, which is F1. So, a short answer to your question, yes, you must have a visa stamp. And whether you have to have interview or just Dropbox, that depending on the embassy, local embassy, and their current pressure at this time. A lot of time they just take your passport in their logbox. They will give a stamp and give it to you. You do not need an interview. Sometimes they may ask for interview, and sometimes yes, you're after the interview they can reject your visa too. So Bottom line, if you do not need to travel to Bangladesh or any other country, you can easily change of your status from within America. But if you think that yes, I may need to go to Bangladesh after 2 to 3 months, then it will save your time if you just go to Bangladesh or other country and change of your status from embassy and come back. Then you do not need to apply for visa stamping again. I hope I answered your question. If you have any other question, you can ask me. Thank you.
Hope that answers your questions. Our next question is from Mr. Muhammadur Rahman. If I started part-time study with F2 visa status, then can I apply later for a change of status to F1? If yes, then are there any limitations for changing status after starting as a part-time student?
So if you said you started a part-time study with F2, yes, under F2 you can study part-time, and you are only eligible to study for like 6 credits per semester, and then you can change of your status from F2 to F1 anytime. And this part-time study, the credit you are receiving under this F2 will automatically added to your profile. So, Samir, can you please show the question again? Yes, F2 visa status. Can I apply later for a change of status to F1? Yes, you can do that. If yes, then are there any time limitation for changing status after starting a part-time student? No, there is no time limitation. As long as you are in valid visa status, you can always change your status from one to another one. So there is no time limitation.
Hope that answers your question. Our next question is from Mr. Imdad Khan. He wants to know that his sister is in USA as a tourist. She is married. She wants to bring her husband as a dependent. Will it be good if she comes to the home country and then apply for F1? As far as she knows, is she may be able to avail the opportunity of Dropbox.
Okay, let me do that. Yes. So depending, it's a very complex question. The reason it is complex is since she is in America with a tourist visa, she can change her status from within America. And once her status has been changed from B2 to F1, then she can apply for her husband as a dependent of F2 visa. And only then only her husband will face interview in US Embassy in Bangladesh. However, she can also go back to Bangladesh. She can apply for F1 visa for her and F2 visa for her husband. They both can apply together, and they both can face embassy, get the visa interview, visa stamped, and come back to America. Dropbox, it is not. It's not like sure that they will only get the Dropbox. Embassy may take her take her passport in a Dropbox, or they can ask for interview. So please do not assume that the only future is the Dropbox. Dropbox may be an option. Visa interview may be an option too. So it depends like how fast she wants to bring her husband. If she really wants to bring her husband fast, I would advise her to change over her status from within America, because it will be faster. There is no interview. It's just application to USCIS. They will approve it, and then she can apply for her husband for a F2 visa. However, if she thinks that they both want to face the interview together, then she can go back to Bangladesh and apply for F1 for her and F2 for her husband.
Hope that answers your questions, Mr. Khan. Now we are attending some questions from our email as well. Our first question is from Mr. Rana Mandal. I have business in the UAE which permits legal money transfer from a UAE bank account to US bank for my E2 visa application. Where should I transfer this fund for the E2 visa investment? Should I open an account in the USA and then need to transfer the money to my personal US bank account? Please provide detailed guidance.
Yes, I would advise you to first come to America with a visit visa, like a B1 or B2 visa. Open a bank account here in America, and also, under E2 visa, you must either start a new business here in America, or you must buy an existing business. So do some background study, like what kind of business you want to start in America, or what kind of business you're going to buy, who are the prospective seller from whom you're going to buy the business, or what is the prospective location. So do some background study, go back to your country, like United Arab Emirates, transfer your money from your personal bank account to your personal bank account here in America, and then apply for E2 visa. That should be like a timeline. So bottom line, first come to America with a B2 visa, do some background activity for starting a business, open a bank account, go back to UAE, transfer money, and then apply for E2.
Uh, he also asked that, as I am currently in Bangladesh, how can I open a bank account in the USA to send money for the E2 application process?
In general, you cannot open a bank account in America while you are living in a foreign country, especially like Bangladesh. You have to come to America with a visit visa or some other kind of visa, and only then you will be able to open a bank account. In some other countries like European Union, Japan, Korea, from there you can open bank account. Let's say you live in UK. From UK you can open a bank account here in America, but from Bangladesh you cannot open a bank account here in America.
Hope that answers your questions, Mr. Mandel. Our next question is from Ms. 𝗦𝘂𝗍𝗆. I have relatives in the USA who can give me money for my YouTube visa application. If I establish a business in the USA, what is the step-by-step process from signing an agreement with a company, suppose a petrol pump or a restaurant, to obtaining the visa? Please provide a detailed explanation on the entire process.
Thank you. So since you have relatives here in America who will give you money, the very first action you need to take is you have to open a bank account here in America, as I said earlier. And then your relatives will give you money, transfer that money from your relative's bank account to your account. And this money must be under a gift certificate. Your relative will give you a certificate that they are giving you a certain amount of money as a gift, and they must show that copy of the certificate in their tax file in next year, meaning they must show that they gifted this money to you. Once you have a bank account, once you have money from your relative, once you have the gift certificate, then you can start opening a new business here in America or start buying a business. That can be a gas station, grocery store, restaurant, or any kind of business. There is no limitation. There are some limitation, however, that it must be a round the year business. It cannot be a seasonal business. Number two, it must be a brick and mortar store. So brick and mortar is a term used for like a physical location business. It cannot be an online business. So once you have this kind of business, like you don't have to buy the business, you don't have to start the business, you just have to have plan for that, and then you can apply for E2 visa. So let me summarize the steps. Number one, open a bank account here in America. Number two, transfer money from your relative's bank account to your bank account. Get a gift certificate from your relatives. Do some research about your prospective business. That can be a new business that you're going to open here in America, or you can buy a old business, existing business. Do some background activity, and then you apply for E2 visa.
I hope you got your answer, Ms. Islam. Our next question is from Mr. 𝗦𝘂𝘍𝗆 𝗟𝗏. I previously had a student visa refusal in Canada. Now I wish to apply for an F1 visa in the USA. Before, I also applied in Canada as a tourist and got a refusal. Will the previous refusal issued in Canada can affect my application to the obtaining an F1 visa to the USA?
Short answer is no. If Canada refuses visa, you can definitely apply for student visa here in America. Even if US Embassy refused your visa earlier for some reason, you can still reapply again for a student visa or other kind of visa. So one rejection, one denial will have no impact to the next application. However, make sure that you provide the same information that you provided to Canada in your US visa application, because Canada, America, and some other countries, they share information with each other. So if they find that there is a discrepancy in application, then they may reject your visa application. But if you provide the true and accurate information, you provide the same information, you can definitely apply for a student visa again here in America.
Our next question is from Muhammad Litan Molla. I am interested in applying for an EB3 visa, and I would like your sister concern company, with American Recruiter, to handle it on my behalf. If I decide to sign with GAR, then does the retainer agreement specify Raju Law's responsibility for making payments to GAR? Because I only know Raju Law Company and your office in Dhaka. Will the employer, McDonald's company, provide accommodation for me if I join them?
So Great American Recruiter is a totally different company. In the retainer agreement, I'm not sure whether our company name is mentioned in the agreement or not, but I can guarantee you, this is a live discussion. I'm guaranteeing you, all of their legal activity is done by us. We take care of all their legal work. So even though our company information may or may not be mentioned in the retainer agreement, but we are part of, we have like a attorney client relationship with Great American Recruiter. So if you want to move forward with Great American Recruiter, please go ahead, do that. There's no problem with that. We are guaranteeing that this is a good company. If you trust us, you can trust them too. They're a good company, they're our client, they do everything in the right way. But I'm not sure whether there is a mention of our name in the agreement. I really don't know. And our office in Dhaka, they also use it sometimes. So if you go to our Dhaka office for any reason, for Great American Recruiter, you can do that. They use our office. So I can guarantee that there's a good company. You can trust them, even though our company name is not mentioned there. You can also reach out to them. You can say, hey, once I sign the contract, can you please mention Attorney Raju Mahajan and Associates company name in the agreement? They may or may not, agree with you. I don't know what is their situation, but you can request them.
We have another question from 𝗦𝘂𝘶 𝗟𝗶𝘆. I have already applied for NIW in June 2023 from Bangladesh and holding a B1 B2 visa. I intend to travel to USA under the B1 B2 visa category and then want to change my status to F1. So can I submit my I-485 petition instead of DS-260 for the NIW application within the USA and without returning to Bangladesh?
Yes, yes, but depending on many factors. So my understanding is that you applied for NIW, so your I-140 is pending or approved. You did not mention that. I'm assuming it's pending, or it could be approved too. In either situation, you have a valid B2 visa, so you're traveling to America. Once you are in a tourist visa, you can definitely change of your status from B2 to F1. And when you will be able to apply for I-485, that depends on visa bulletin. Every I-140 application and also every I-130 application comes with a priority date. So you have to check the visa bulletin every month and see when your priority date is current in the visa bulletin. And there's two boxes. One is date for filing, one is final action date. When your visa bulletin priority date is present in visa bulletin for both boxes, only then you can apply for I-485. So yes, you can come to America with a V2 visa. You can change your status to F1. You can wait until your priority date is current, and then you can apply for I-485. You do not need to go back to Bangladesh for DS-260. You can adjust your status from here too.
Hope that answers your questions, Mr. Molla. In the meantime, we have got another question from Mr. Mohammedur Rahman. Is there any problem to go to Canada to stamp my F1 visa after receiving F1 approval within the USA? Are there any difficulties? Also, is there any chance to lose my F2 visa during my visa stamping in Canada? My F2 visa will expire in 2028. Thank you for your answer.
Yes, Samir, please keep this question here. So yes, once your change of status is approved from America, you can definitely go to Canada and apply for your visa stamp from US Embassy in Canada. However, as soon as your change of status from F2 to F1 is approved from America, you already lost your F2 status. So you do not have a F2 status at that moment, even though you're going to Canada and applying for visa stamp. Let's say worst case scenario, the US Embassy in Canada is rejecting your F1 visa stamp. In that moment, you have no visa at all because you already lost your F2 visa earlier and now you lost your F1 visa application again. At that moment, you do not have any US visa. You cannot come back. However, since your original visa was F2, meaning your spouse is a US student here in America, so if your spouse is a F1 visa holder, you can apply for your F2 visa again, and you can come back to America, either from Canada or from Bangladesh or any other country. I hope you understand the dynamics. As soon as your change of status is approved, you lost your previous status, you move to a new status. Then if you go to a foreign country to get the visa stamp, if they reject it, then you also lose that status. So in that moment, you have no status at all. You have to apply for a fresh F2 visa application again.
I hope that answers your question, Mr. Rahman. We have another question from Ms. Emily Marshall. Why are you saying if you travel to Mexico or Canada with a change of status, the individual needs to get a visa stamp? What about visa revalidation?
The reason I mentioned that, there's two things. One is a visa, one is a status. These are two different things. Anytime you change of your status, you receive a status. You do not receive a visa. No US government agency has authority to issue visa. And in general, people do not need visa to live within America. They only need visa if they go out of United States and try to come back to America. You only need visa to pass the airport. You do not need visa for other reason. So if anybody change their status from within America, they can stay in America happily. There's no problem, but sometimes they need visa stamp, and in that case they can either go back to your home country, or they can go to Mexico or Canada, because Mexico and Canada are two neighboring countries. Those who are living in southern states of America, they usually go to Mexico. Those who live in the northern states, they usually go to Canada. So that's why I said that if you travel to Mexico, Canada with a change of status, the individual needs to get a visa stamp. What about the visa revalidation? So visa revalidation is very different. It's more of a visa kind of like renewing. But from change of status to visa stamp is just a stamping.
Ms. Emily Marshall further asks, can you speak if USCIS still uses the 90-day rule with regards to change of status?
It's a very good question. I intentionally avoided this topic because, so usually 90 days rule is not for change of status. 90 days rule is for adjustment of status. When people apply for green card, 90 days rule applies. 90 days rule do not apply for change of status. However, it's good to wait, at least 60 days, 90 days before they change their status. That looks good. That authenticates their intent of changing status. So let's say you came to America with a valid B2 visa, and within a week you were eligible to change of your status from B2 to F1. There is no problem with that. There is no legal problem with that. However, that raises a question: then why did you, if your intention is to study in America, why you did not apply for F1 visa at the first time? Why did you apply for B2, came to America, and then within a week you are changing of your status from B2 to F1? Just to avoid this kind of question, just to avoid this kind of like unpleasant circumstance, we say yes, please wait a little bit. 90 days is a good time, and then you apply for change of your status. But 90 days rule is not applicable for change of status.
I hope you got your answer, Ms. Marshall. We have our next question from Mr. Roger Watson. Hi, dear. Please, can I use my friend's bank account in order to apply for change of status? I hope that's order.
Yes, you can do that if your friend is a US citizen.
We have our next question from Mr. Nurul Aziz. I am going to apply EB3 from Bangladesh through your law firm. My friend having business in Florida employing me under unskilled category. Sir, can you please tell me what is possibility of my case through consular processing? I visited USA last year through J1. Please advise.
So, what is the possibility of my case through consular processing? So EB3 is a very hot topic at this moment. A lot of people, they're getting green card through EB3 and they're coming to America. So I am very confident that your case will go through the consular process. You will face visa interview. You and your family will face visa interview there in Bangladesh, US Embassy Bangladesh, and you will get the green card and come back to America. At the same time, I must tell that there is no 100% guarantee for anything in the world, including immigration. So your application, I'm very confident that it will be approved. You will get the green card, but also there's a little chance that it may be rejected. Also, since you visited America with a J1 visa, why not you try to come to America with a B2 visa again? And if you come with a B2 visa here in America, especially before your third step, your adjustment of a status step, then you can adjust of your status from here in America. You do not have to face the consular processing. You do not have to face the US Embassy in Bangladesh. So that will sometimes that shortens the time, that makes it a little easier. But also, staying in America with a valid visa also requires like a lot of other requirements. So bottom line, short answer to your question, I'm very confident that you will go through the consular process and you'll get the green card, you'll come to America.
Our next question is from Kanta's Family Outing Channel. I, with my husband and one child in USA, in B2 for a week. This country has really awesome environment. How can I convert my B2 visa to green card? If you explain me the routes and possibility.
It's a very big question, very vague question. You can definitely change of your. Change means like you have to go through a lot of process, and it depends on your background. So I will suggest you to take a paid appointment either with me or any attorney, Also watch some YouTube video, do some study, and see which category is good for you. There's a lot of categories, it depending on your background, your education, your work experience, and then you can see what is the good path to get green card here in America. You can definitely stay in B2 visa. You said you are in B2 for a week, so you have kind of like another 5 months, 20 days. Within this time, you have to find a way to apply for green card, and only then you'll be able to adjust your status. So, short answer to your question: yes, you can do that. That depends on your background.
Our next question is from Mr. 𝗦𝘂𝘗𝘆 𝗟𝗶𝘆 Those person who have European citizen and move in USA for settlement, how they settle in USA?
Same answer. It depends on your background. It doesn't matter you are a citizen of European Union or Bangladesh or Nepal, Sri Lanka, or any country. The way you will get the green card is the same. It depends on your background. It depends on your education, work, business, or other kind of background. If you qualify for any of the green card application categories, you can apply, and then you can get green card and stay in America.
We have another question from Miss Emily Marshall. Why are you saying you can only file the I-485 when your date is current on both tables? On the USCIS date for filing, they are accepting I-485 with the filing chart for family-based petitions.
I simplified it a lot of time, in this kind of discussion. So again, let me tell you. So this is not a legal advice. This is for information purpose only. And a lot of time, depending on many situation, depending on many updates, we advise differently to each client. In this discussion, I just try to make it very simple that people understand. So if you want to talk about your specific situation, I advise you to contact us a different way. Take like our appointment, give us all of your information, including the priority date, your category of application. We will see what is your current status, current situation, and when you'll be able to apply for I-485, we will tell you. But when we talk in this kind of like a live discussion, we just try to make it simple that people understand.
Hope that answers your question, Ms. Marshall. We have next question from Mr. Nurul Aziz. Can I go to USA now with B2 visa without applying J waiver? Sir, please advise, can I apply for B2 visa with family? In that case, should I make an appointment with you?
So my question is, since you already came to America with a J1 visa, and I believe you have a home residency requirement, did you complete that home residency part? If not, then if you apply for a B2 visa or like a F1 visa, the embassy may reject it. Embassy may say that, well, you have to complete your home residency first, and only then you can apply for either B2 or F1 application. A lot of time I saw that even people did not complete their home residency requirement, they still got F1 visa. They came to America and then they applied for waiver later. So everything is possible. You can definitely take appointment from me, but I would advise you to apply for B2 visa or F1 visa first. See whether embassy will approve your visa application or not, and then you can take my appointment. Otherwise, you can definitely talk to me. It may be a waste of time.
I hope that answers your question, Mr. Nurul Aziz. With that, we have no more questions coming in. Thank you, Mr. Mahajan. Is there any important immigration update this week?
Yes, there are some good immigration updates. Let me. Number one is new version of Form I-9. So, effective from October 31st of 2023, USCIS introduced a new I-9 form. So those who are going to, I'm not going that detail into I-9 because this is just a news purpose. Those who need to submit I-9 form, just remember from October 31st, 2023, you have to submit a new I-9 form, new version of the I-9 form. Also, USCIS announces that it would update its visa availability approach for managing the inventory of Form I-526. Again, I'm not going that detail into 526 form, but those who are going to submit the Form I-526, USCIS announced that it is going to update the visa availability approach. For family immigration purpose, public charge is a big deal. Public charge is a big rule for family immigration. So USCIS updates policy manual of Form I-485, especially for public charge grounds of inadmissibility. Those who are taking different, government subsidized benefits, I always say that try your best not to take those. But also, there's a new policy. Please try to check the policy and see if the benefits you're taking right now falls within the category. Last update is from fiscal year 2023. The wait time improved for both Form I-485 and for I-130. However, the processing time for Form I-129F, the first step in the K1 visa application process, remains high. So the short summary of this news is, there's a huge waiting time for I-485, I-130. So it is getting improved. The time is getting shorter. However, for Form I-129 and K1 visa, the processing times remains very high. So those are latest update from USCIS.
With that, thank you, Mr. Mahajan, for today's live session. I'm sure our audiences have enjoyed this session thoroughly. Thank you so much, everyone, for watching. We'll see you next week at the same time. Thank you.
The EB3 visa, a subcategory of the employment immigration visa, is a powerful option for professionals, skilled workers, and unskilled workers hoping to get permanent residency in the United States. Through the EB3 visa, a U.S. company can sponsor a foreign worker for a green card through a full-time job offer. Raju Law, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.